Hey folks, criminal defense attorney Keith Stickley here with the Stickley Law Firm in Hillsdale, Michigan. You know, a lot of people who are first charged with a crime or have somebody that they care about who's charged with a crime, specifically a felony, are often at a loss of what's going to happen and how the entire process works. And I wanted to take a few moments to sit down at my desk and thoroughly explain the substantive process of the various hearings, what they mean, and what happens when somebody is charged with a felony crime here in Michigan. It can be kind of confusing, and a lot of times, especially if you're using a public defender, you feel like you get lost in the shuffle and you don't exactly know what is supposed to be happening when. Meanwhile, the attorney is up there doing the attorney things, and that can really be scary. That can be difficult for some people, and I realize that. In fact, I was talking to a client this evening about it, and it sort of provided the inspiration. Well, what if I could explain sort of the process, sort of the timeline of the various hearings and what happens, so that somebody who is just getting involved in this and is starting to go through it or cares about somebody who is, can have a better understanding before they even get to the court or maybe even talk to their lawyer or retain an attorney to understand the process and what is going to happen, develop some sort of realistic expectations. So let's sit down and let's talk about the anatomy of a felony case in Michigan and what's going to happen. So the question is, what happens when you're formally charged with a felony in the state of Michigan, and how does this court process sort of unfold as you go through the process? Well, let's start from the beginning, and we're going to assume that the person we're talking about, this fictional person, I might refer to it as you, but I don't mean obviously you specifically, but the fictional person is going to be charged with one count of larceny. That's a felony, okay, stealing something, all right? And this goes for pretty much every felony that is charged in Michigan, but that's just the example that we're going to use. So traditionally, there's some sort of a police investigation or a police report made, and they supposedly do their due diligence, and they write up a police report, right? We've all heard of a police report. No big surprises there. After the police report and investigation is complete, if the police think that there is a crime, that a crime has been committed, then they will send their police report and some documentation to your local county prosecutor. Now, the prosecutor in the state of Michigan is elected per county. Every county has one elected prosecutor. But technically, they sort of represent the state, okay? They're referred to as the people. If you hear people talking about the people in a courtroom, they're referring to the prosecutor or the state. It's interesting to know that in Michigan, you don't really press criminal charges against somebody. A lot of times people, like in an assault and battery case, they might say something like, hey, well, John Smith isn't actually pressing charges against me, so why is this case going forward? Well, it's not John Smith, that the victim, that actually presses the charges. It helps if they cooperate, but technically the people can press these charges, authorize these charges, without the cooperation of John Smith, up to a certain extent. And if you're in that kind of situation, make sure to ask your lawyer about it, because your lawyer will explain. So the prosecutor signs information, signs some paperwork, and that can sometimes lead to an arrest warrant. And that is permission for the police to go and arrest the person who is suspected of committing the crime. So let's assume that you are being charged with a larceny. The police have requested the prosecutor sign charges. The prosecutor thinks that a crime has been committed based on the report, and so they sign the warrant. The warrant goes out, and now a police agency will generally try and go out and serve the warrant, which means basically arrest you, okay? And oftentimes when you're arrested, you're brought to jail. And the first thing that happens when you're brought to jail, one of two things can happen. Number one, there's a preliminary bond that can be set. Preliminary bond. It's not all the time and not in every county, and this varies widely. But a preliminary bond is an amount of money that you can give to the jail that guarantees you will show up for your next court hearing, okay? For instance, if you are booked into the jail on this larceny charge, the local sheriff might say, well, if you post a $1,000 cash bond, in other words, you give us $1,000 to hold on to, we will let you go. And as long as you show up to all your court hearings at the end of the trial or at the end of the case, you'll get your money back. In theory, that's how it's supposed to work. But what happens most often with serious felonies is you're arrested, you're brought to the jail, and you sit in jail for up to 72 hours until you have your first hearing. And that first hearing is called an arraignment, the arraignment. Now, an arraignment is a formality where a magistrate or a judge, you don't always have a judge at the arraignment, sometimes it's a magistrate, they formally inform you of what the charges are. They formally read you what the charges are. There'll be a paper, a charging document, and they'll say, you, John Smith, are formally charged with the crime of larceny, 2000 to 7, whatever the actual law is. And they'll usually cite the law, and they will tell you about your rights. And you have the right to a jury trial. You have the right to an attorney. If you cannot afford an attorney will be appointed or provided for you. Now, sometimes this is a little bit of a misnomer. Sometimes you actually, even if you have a public defender that's appointed for you, you still have to reimburse the county. You still have to pay for that public defender. Public defenders are not always free. In fact, quite often they're not free. And sometimes that's why, if you're going to pay anyway, you might want to consider hiring counsel. So the judge informs you of that, and then you enter a plea. Now, this arraignment takes place in a district court. Okay, that's important. A district court. A district court is a lower court that only handles crimes to completion that are punishable by up to 1 year. But in Michigan, all crimes, all criminal cases start in the district court. Your local district court, wherever that crime is said to have occurred, that is the district court that you will be arraigned at. So once you are in front of this judge or magistrate, if it is a felony, they will pretty much always enter a not guilty plea on your behalf. And you really should enter a not guilty plea because there's so many moving parts and things and strategies that can go into a felony case. You don't want to just give up the goose and start making statements. I can tell you, at an arraignment, you are going to be provided, you should be provided, with some sort of legal counsel. There will probably be a public defender there, just for helping everybody, pretty much, unless you've already pre-hired an attorney. There'll be a public defender there, and that public defender sits there as the arraignment attorney just to make sure that all your constitutional rights are intact and the court doesn't try to do something goofy. And that public defender is also going to help you with the next part of this puzzle, which is called the bond argument. Okay, so you enter a not guilty plea, and then you talk about bond. And bond, like I mentioned before, not an interim bond, but the formal bond for the case, is the formal declaration of what you need to post to guarantee that you will show up for your court hearing. Now, the state of Michigan says that they specify out in the law that the purpose of bond is twofold, and only twofold. Number one is to protect the community, to protect the safety of the community. So the public defender who's helping out with arraignments, or yourself if you want to represent yourself, puts together an argument that shows, you want to show the court that you are not a danger to the public while this case is proceeding and going through. How do they do that? Well, there's a lot of different ways. If somebody's accused of larceny, simple theft, there's probably not a big safety issue, a life, liberty, safety issue to the public, okay? So that probably won't be a factor that would increase what a judge or a magistrate would want to set bond at. But on the other hand, let's say you're being accused of murder, let's say you're being accused of rape, any of the heinous crimes, even though you're innocent, that bond consideration, they'll take that into consideration as a potential public safety problem. And your bond will probably be much, much, much higher. So that's the first part of bond. The second part of bond is to ensure that you're going to return to court for all of your court proceedings. So this is where things get a little bit controversial. And sometimes you see arguments on the news now talking about bond and bail reform. And the argument comes in, well, if somebody posts $5,000 bond as a promise to show up for court, is it really a bigger incentive than if they have to post $1,000? For instance, does it keep the community any safer if the person who's being let out on bond gave the court $1,000 versus $5,000? If they're going to violate their bond and potentially lose $1,000, they probably don't care about $5,000, right? So that's kind of a sticky thing that's working its way through our communities. But regardless, that's where you have your arguments of, are you going to return to court or not for your court hearings? And the magistrate will have a sheet. They will have a printout with, if you have any sort of criminal history or court records. And it will specify if in your past you ever had a court hearing that you were supposed to go to, that you didn't go to and that you missed. And they will take that into account as well when setting some kind of a bond. If you've missed court dates in the past, they are going to think that you don't take court very seriously, so they're going to want you to have a lot more skin in the game, right? So they will probably set the bond amount, the financial amount, at a higher level than if you've had maybe a couple of cases and you've always showed up to court and there's no problem. So those are the two arguments regarding bond that you or your magistrate are going to make at the arraignment process, during the arraignment process. And the magistrate might also ask you some questions about, where do you live? Do you have a criminal history? In certain assaultive-based crimes, they're going to want to know where you're going to be staying and make sure that you're not having any contact with somebody who's potentially accusing you of a crime. The arraignment process can be very frustrating for some people because it's really important to note you cannot offer any defenses at the arraignment. You do not want to talk about anything that actually happened, the actual allegations during the arraignment. The attorney can't really help you. And that's one of the most frustrating things that I've noticed a lot of people have during the arraignment process, because especially if they've never been they're not like a career criminal. They've never been accused of this kind of thing. That is, they just want to tell their story, right? Because they're like, hey, look, I'm innocent. Like, I got to tell somebody. They got to know, so they'll let me out. And unfortunately, you got to go through the process. You got to go through the steps. So that can be really, that can be frustrating for some people, but it's important to know just you got to go through it. It's something you got to do. You got to keep your cool. At this point, one of two things happens. Number one, they set a bond amount and you can post the bond, and the jail will tell you how that works. If you can't afford to post a bond, that's when you call a bondsman. And you basically rent money from a bondsman. So if your bond gets set at $2,000, right, and you don't have $2,000, you can call a bondsman. And what a bondsman will do is a bondsman will give the jail $2,000 to let you out. But in order to get the bondsman to do that, you have to pay the bondsman, whatever the bondsman wants. Like, he might want $400. You're basically renting his money. And you don't get that $400 back. You're hiring him to put up his money. Why does a bondsman do that? Isn't that interesting? Well, they do that because when you work with a bondsman, the bondsman will come and capture you, physically capture you, arrest you. No warrants, no anything. You sign all these waivers. If you don't show up for court, they don't want to lose their money. So their job literally is to go out. That's what the bounty hunters are. If you ever heard of Bounty Hunter, maybe you watch Dog the Bounty Hunter. What's happening when they go to catch those guys is those are people that paid the bounty hunter to the bail bondsman company to pay a bond, but then they didn't show up for court. So the court wants to take the bondsman's money, the bail bondsman's money. They want to keep it. And if the bail bondsman goes and catches the guy and brings him back to court, then the bail bondsman gets to keep the money he put up, and obviously he gets to keep the money that the client paid him to rent his money. So that's number one. You can get released if you post a bond. If you can't post a bond, then you're sitting in jail. And there are a couple of cases where judges and magistrates will not allow bond to be given, regardless. And there's certain statutory crimes in the state of Michigan, CSC 1, life offense, for instance, homicide, murder 1, for instance, where bond is not required to be set. And in those serious cases, often bond isn't set. You're sitting there. You're going to be sitting there for the duration until the case is over. And so bond is important. It's a tricky thing. I can tell you, sometimes you can avoid some of the bond posting of the money processes if you retain an attorney. We do this for our clients a lot. A lot of times we find out that somebody has a warrant for their arrest. And an attorney, we do this often, can actually arrange a turn in. In other words, we can bring a client to the court and for an arraignment, basically a walk-in arraignment. And at that time, it is very, very likely that the judge will give you what's called a PR bond. In other words, you don't have to post any money. They eliminate the warrant and you get to go home. Now, you will be given bond conditions. You'll be given a list of rules that you have to follow, and you better follow them, because in some cases you can get in more trouble for violating bond and do more jail time for violating bond than if you're convicted of the crime you're being charged with. So you're going to be given a list of things if you get bond, and you got to abide by them. The common ones are no alcohol. You can't leave the state without permission of the court. And your attorney will go over that with you, and you'll get some papers about that as well. That brings us to the second big court hearing, and it's the first substantial court hearing. And this one's also a bit confusing for people, and that's called the probable cause conference. Some courts still call it a pre-exam conference, but that's not the correct terminology. The correct terminology is laid out in the Michigan statute is a probable cause conference. And what a probable cause conference really is the first time, it's the first formal time that your defense attorney and the prosecutor will meet and talk about the case, exchange what's called discovery or evidence. They make sure that they have all the evidence that they need. And they also often don't have everything, but everything up until that point. And every once in a while, depending on the nature and the severity of the crime and how much work law enforcement and the prosecutor has done, every once in a while, the prosecutor will just straight up offer some sort of a plea deal. Like, hey, look, admit on the record, plead to this lesser charge, and we'll dismiss the serious charge. Your attorney that you're working with, and you will be working with an attorney by this point, either your own retained attorney or a public defender if you qualify for one and can't get your own, will explain this in great detail. They should, and if they don't, you're working with the wrong person. But the reason we have a probable cause conference, and this is only a development, I think, since 2015, Michigan didn't used to have these, is that a lot of times for the next hearing that we're going to talk about, called a preliminary exam, which is important that there's communication, a lot of times a criminal defense attorney and a prosecutor wouldn't have time to sit down and really kind of powwow and exchange information and evidence and things like that. And so they'd get to a preliminary exam. Nobody really knew what was going on. And it was a cluster, and it wasted the court's time, and they were getting adjournments, and it was stacking up the courts. So the court system said, look, we're going to have this probable cause conference, and we're going to exchange information, and the court mandates, it's kind of a safety valve in case the defense attorney and the prosecutor and the client are not able to talk beforehand. A good attorney will do their best. Sometimes it's not possible, but a good defense attorney, we always try and talk to the prosecutor before the probable cause conference because you want to get all your ducks in a row as early as possible. That's critically important in providing a good defense for a client. So that's what happens. The client is generally not involved in this probable cause conference. Now, sometimes they're given a recap, sometimes they're given some information, but the other thing that happens at the probable cause conference usually is you make the determination of if you're going to go to the next step. The next step that we're going to be talking about is called a preliminary exam. Now, we're still in district court, the lower court. A preliminary exam is like a mini trial, okay? It's like a mini trial where the prosecutor has to prove to the district court judge that there is enough evidence to show that there's probable cause. It's a very low standard. It's not guilty beyond a reasonable, nothing like that. Just it might have happened that there's probable cause that a felony crime occurred. Now, as you can imagine, this is a pretty low barrier, right? Just based on simple evidence provided, it's pretty easy to convince somebody that a crime might have been committed, and that crime is a felony. Smart prosecutors who are sharks, really any attorney, can prove, if they dig hard enough, that you committed some crime, right? I mean, that's just kind of goes with the territory. But if a prosecutor's not able to meet that low burden, two things can happen at the preliminary exam. Number one, the judge can completely dismiss the case. It's pretty rare. Man, it feels good as a defense attorney when we're able to make that happen. You short circuit the whole thing, it's done, client goes home. We get those, and it's just an awesome thing. Or at the preliminary exam right before it starts, that's also a very common time where the prosecutor will go to the defense attorney and say, hey, look, if we don't run this exam, this mini trial, we're going to offer this plea deal. Have your client plead to a lesser charge with a lesser sentence, and we'll move on. And sometimes it's not a bad deal for the client. If the client knows, they really screwed up and they're probably going to do some serious time, and an offer comes in that's quite low, that can be, you could take advantage of that. And your defense attorney will hopefully be skilled enough to make that determination and communicate that to you. A preliminary exam can also be a very valuable tool because it's a tool used to preserve evidence. During this mini trial, just like a jury trial or a bench trial, both sides can call witnesses to the stand, and those witnesses are sworn in, and they can give testimony. And everything in that preliminary exam is recorded and becomes part of the public record. And why is this important? Well, sometimes there are witnesses for either side that people are concerned aren't going to show up or might not be available in the future. And in those situations, it can sometimes be smart to have a preliminary exam because you're preserving that testimony. And that preserved testimony can be used in the future if there is a trial. I'll tell you, as a criminal defense attorney, sometimes a preliminary exam is also an incredible tool because it's a time where your criminal defense attorney can put investigators and law enforcement, police officers on the stand, or potential victims on the stand, and get them to tell their story. And when they tell their story, when they tell their narrative, because I get to ask questions, they get to be cross-examined. Once that all gets documented, in preparation for a trial, a good criminal defense attorney goes over that information and looks for discrepancies. That's a good way to catch law enforcement officers for lying. So you can tear down their credibility. It's not uncommon for police officers to say things on the stand in a preliminary exam, and then when you get to like a jury trial, suddenly their story changes. And then your criminal defense attorney gets to go, oh, really? That's your story today? Well, how come at the preliminary exam you said X, Y, Z, and you can bring that in to discredit the investigator? Same exact thing with an alleged victim. Let's say there's a victim who claims to be a victim, but maybe they're really not, and they go to the preliminary exam and they give testimony. Well, I got news. Liars have a real hard time keeping a straight story, real hard time. And that becomes really fun because you then have a story that they are nailed down to. And if they are a liar and you end up in a jury trial, it is not uncommon at all for their story to change. And you can bring in what they said at the preliminary exam in front of a jury and prove that this is not a credible witness, that they're a liar, and that you shouldn't be held guilty. So that's kind of how a preliminary exam goes. Now, often people who are watching court, they notice that many preliminary exams are waived, okay? Or they're elected to not be held. Now, why is that a good thing? If that's your right to a preliminary exam, why would you waive it, right? This seems like a great tool. Well, for every part A, there's a part B, right? Every pro, there's a con. There are certain situations where having a preliminary exam when you're charged with a crime can really, really hurt you. And that is because sometimes testimony will be given by a victim or an investigator or something that is basically a new allegation that you didn't get charged with. The really, really common one is in criminal sexual conduct cases, rape cases, basically, where somebody, the stereotypical scenario is a defendant is charged with one count of, let's say, rape. And they elect to have a preliminary exam, and a victim gets on the stand who was the alleged victim of this rape. And the prosecutor might ask them, okay,
How many times did a penetration occur, or how many times did a molestation occur? And let's say the alleged victim says, oh, it happened 4 times. The prosecutor has the right to amend the case, to amend the charge and add charges on right then and there. And you don't get a probable cause. You don't get any of the benefit of advanced negotiations. The charge will be amended, and the case is going to go to the high court, okay, to the circuit court, which brings me to what happens after the preliminary exam. You can waive your preliminary exam, and when you waive it, that's what's called being bound over. You are bound over to the circuit court. If you don't want to have a preliminary exam, you have to sign some paperwork, and your case is the file is physically moved from the district court to the circuit court in front of a circuit court judge for future hearings. If you have a preliminary exam and the district court judge finds that there is enough evidence that constitutes, in the scenario, in the situation, constitutes having probable cause, the judge will find there is a finding of probable cause, and then the judge will bind it over. In other words, they'll literally take the file and they will send it to the circuit court for future hearings. That's the big court. Every once in a while, you get a scenario where you have a preliminary exam, and the judge finds that a crime was committed, but it doesn't rise to the level of being a felony. What happens then? What happens then is there is, the judge will say, there's not enough here to bind over on a felony, but I do find that there is potentially a misdemeanor charge. Misdemeanor cases stay in the district court. They stay in the small court. So the judge will make that ruling, and then there'll be a pretrial and all the things that happen in a misdemeanor case, which we'll be discussing in another video. And then, of course, every once in a while, there's a preliminary exam where everybody testifies and does all the thing, and the judge just finds it preposterous that the prosecutor even brought this case to begin with, and the judge will just dismiss the case. The judge will say, there's no crime here. I'm dismissing it. Now, that is rare as hen's teeth. There's a saying and a belief amongst many criminal defense attorneys that, most district court judges, you probably won't think I'm very popular for saying this, but it's true. Most will bind over a turkey sandwich. What does that mean? Well, the barrier's so low to kick over a case that a lot of judges, district court judges, they just rubber stamp these preliminary exams and they send everything over. So it's critical that you really strategize and get some explanations from your attorney of whether or not it is smart to have a preliminary exam. Now, there's a lot of people that hear things like, because a lot of judges will say, before you're going to skip a preliminary exam, this is your right. Do you want to give up this right to a preliminary exam? And that can strike terror in the minds of a lot of people. I don't want to give up any of my rights. I'm innocent, whatever. It's so critical to talk to your attorney. Your attorney might have a really valid strategy that's going to help your defense. Just because you have a right does not mean that you want to utilize that right, because having rights can harm you just as much as they can help you. And that's something that you're going to have to rely on the counsel of your attorney to help you make that decision. Now, in the end, and I tell all my clients this, the decision is always yours. And if you want to exercise your right to a preliminary exam, that's 100% okay. Even if I advise my clients against it, if my clients are 100% gung-ho and want it anyway, I'll do it. And I'll do it to the absolute best of my ability. The flip side of that is they really might not like the outcome. It really might hurt them in the past or in the future, rather. And that's the risk that they have to take. And that's why you hire a criminal defense attorney. And that's why you hire a competent criminal defense attorney with a track record of getting wins and reductions. So I kind of jumped the gun a little bit. We did talk about the bind over and what the bind over is. So I'll just go over that real quick. After a preliminary exam, either waiver or a finding of the judge, the case is sent over to the circuit court for future proceedings. Now, here's a weird one for you. It's a little bit fuzzy. This is a situation where technically, if you read the court rules, and this boggles my mind that more judges don't, and they don't comply with this, but If you actually read the court rules say that if at the preliminary exam or in any of that early stuff in the district court that there is a plea that can be made, there's a plea offer and a plea offer taken, the district court judge should be able to take your felony plea. It's right there in the Michigan court rules. I practice law in many jurisdictions, and it's amazing the amount of jurisdictions where a district court judge will take a felony plea is shockingly low. And I ask them why. I challenge them on it all the time, and a lot of them look at me like I have two heads. Well, that's just not what we do, And I'm just like, okay. I mean, I don't know why it's in the court rules if it's not allowed, but there it is. According to the court rules, a district court judge could take a felony plea. Now, they won't sentence on the felony plea. If you in the jurisdictions that actually abide by the court rules, which we have to abide by every other court rule. I don't know why we don't abide by this one, but if a district court judge does take the plea, then the case goes over to the circuit court for sentencing. So the circuit court judge will be doing the felony sentencing. And I think that's maybe where some of the conflict comes in, because there's a question of, are you entitled to be sentenced by the judge that you gave a plea to? And that's kind of getting in the weeds. If you have further questions about that, and I'm your attorney, please feel free to ask. I'd be happy to explain it or ask your attorney that you're working with. So this takes us to sort of the fifth step of the process, and that is the circuit court arraignment and pretrial hearings. Now, much like we had an arraignment in district court when the case first started, as soon as your felony case gets bound over to the circuit court, we have another arraignment, basically a formal reading of the charges so you know what felony you are being charged with and has been brought over. And sometimes there are lesser offenses, like if in one case you're charged with one felony count and a couple of misdemeanors, sometimes they'll follow you over. And so you are entitled, if you want to have a formal reading of those charges. Now, by this time, it is just a formality, because by this time you probably are very, very familiar, if your attorney has done their homework at all, of what it is you're formally being charged with. And a lot of attorneys will advise their clients to waive a formal reading because it's kind of just a waste of time, and it kind of cranks off most judges. Also, coming up with the arraignment oftentimes is a pretrial. If the pretrial doesn't happen at the arraignment time, then it'll happen afterwards. And the pretrial is just that. It's an informal conference between your criminal defense attorney and the prosecutor to see if there is any sort of a resolution, where this case is going. And it's surprising how many cases get worked out to some resolution. A lot of people talk about, well, how do pretrials work, and why do prosecutors offer pleas? Well, to bargain is just part of human nature. It really is part of human nature. And people that take the stance of, we don't need to plea bargain. People should just, plea as charged and whatever. Well, I can tell you, you can claim you're going to plea as charged all day long, but prosecutors, as a rule, overcharge all the time. And people, it's just human nature to want an incentive to get some sort of a deal or make things not as bad if they take responsibles for some part of it. So a lot of those negotiations and discussions happen in circuit court pretrials. And some judges adhere to a much stricter timeline than others. Unlike a probable cause conference and pre-exam conference, where there's some clearly defined statutory timelines that things need to occur within, unless you waive those timelines. And by the way, you should listen to your attorney about waiving timelines. Sometimes waiving timelines can work out to your advantage in massive ways. So you don't always want to just, stick to, the prescribed timeline. But I digress, getting ahead of myself. In circuit court, the timelines are much, much more flexible. And if you want a full jury trial, in many jurisdictions in this state, it takes months to get on a calendar for a jury trial. Oftentimes, there'll be more than one pretrial. You'll say, Judge, there's some things that we have to do. There's some things we have to work out. So we'd like, to come back in front of you in 4 weeks for sort of a status conference and let you know what's going on. And it's amazing how many different things can come up that just need time. They just need time. And that's one of the hardest things I think that a lot of clients have, sort of wrapping their mind around, is that when their attorney's doing work and trying to make things happen so that they are put in the best possible scenario, those timelines can get, and that wait time and the unknown can get really, really frustrating, especially if they're incarcerated. Because this whole time, some people accused of some crimes can't make bond. They can't bail themselves out of jail, or they can't have the financial means to do so. And so it's important to develop a rapport and communication with your attorney. It's one of the things that we sort of prioritize. All cases are really important to us, but we do try to prioritize communication and getting cases seen to completion, whatever that completion might end up being, with people who are incarcerated. Because I mean, God forbid they're innocent, which does happen frequently, actually, and you don't want somebody losing their liberty, and sitting in jail with a bunch of nasty, crusty inmates when they need to be living their life on the street. So we take that into a big consideration. Let's assume, and by the way, also in the pretrial, sometimes a plea is had. So during pretrial negotiations, if the prosecutor and the defendant come to an agreement, through the criminal defense attorney, they'll inform the judge at a pretrial hearing, Judge, we would like to enter a plea. We have a resolution on this case. And then the judge goes through a series of questions, making sure that the defendant understands their rights. Nobody's threatening them. Nobody's bribing them. All this is put on the record. And then the judge asks for a factual basis. In other words, you actually have to articulate what it is that you did wrong that qualifies for this conviction. Sometimes there'll be a thing called a no contest plea, which is where the judge doesn't ask for any sort of factual basis. You don't formally admit that you did something wrong, but that you admit that something happened, and you allow the judge to take the police report or whatever report that you agree with the prosecutor into consideration as the factual basis, and then you proceed to sentencing. Let's assume that hasn't happened. Let's assume that there's no plea that can be worked out. Then you go to a jury trial, and the judge will give out a scheduling order, which is a bunch of more timelines. There's a lot of timelines. A lot of scheduling goes into this stuff, and some of the timelines will involve how much time that both parties have to serve motions on each other. There's a lot of technical law stuff, motions in limine. They have to make sure that they have exhibits exchanged. Is there any evidence that are going to go back and forth? A really big one is the defense side has to, and the prosecutor side, they have to tell each other who they plan on calling as witnesses in the case, because they have the right to kind of background and interview the witnesses before the trial. And so all that stuff happens on a scheduling order right before a jury trial. And you have the jury trial, the stereotypical jury trial, where, in Michigan, if it's a felony, you get 12 jurors, and both sides present their case. And whatever happens. Either you're convicted and then you proceed to sentencing, or you're acquitted and you're not guilty and you walk out of the courthouse a free person. If you do plead, let's talk about that. Let's talk about the resolution if there's a guilty verdict or a guilty plea. So if you're found guilty by plea or a jury trial, the next step on your journey through the criminal justice system, will be called a PSI, a pre-sentence interview or a pre-sentence investigation. The Michigan Department of Corrections, a probation agent, will sit down with you either at the jail, or if you're out on bond, they will bring you into their office, and you will fill out a detailed personal and criminal history. You'll talk about your childhood. You'll talk about potential substance abuse stuff. You'll talk everything. They want to know everything about your life, because in Michigan, sentences are supposed to be crafted and narrowly tailored to provide, yes, for the punishment, but also for the rehabilitation, if possible, of the defendant. And through that process, there will be a sentencing guideline range, a number range. And that is a guide, a suggestion for if somebody's going to end up being sentenced to jail or prison, how much time in incarceration they should spend. And your criminal defense attorney will be talking a lot, if they're worth their weight in anything, about sentencing guidelines and whether or not that is an acceptable resolution if you're pleading, or what you might be up against if you lose at trial. So we spend a ton of time with our clients on sentencing guidelines. I'm a firm believer in, if my clients know what the potential worst case scenario is in a case, then the entire outcome is not as scary, because we know if we know the absolute worst case, if we lose everything, then we start chipping at the block, chipping at the process, and we see, okay, well, if we can win this point or get this reduced or whatever, this isn't as bad. Or if we can win the whole thing, there is no incarceration. And hopefully that's the best case scenario that you're able to achieve. So this pre-sentence investigation process happens. When it is complete, it takes various amounts of time in different jurisdictions. Sometimes it's quick, sometimes it takes a long time. But as soon as that report is complete, it is forwarded to the judge, it is forwarded to the prosecutor, and it is forwarded to your criminal defense attorney. Now, in Michigan, I honestly forget it off the top of my head. It has to be delivered either 48 or 72 hours. I think it's at least 48 hours prior to your sentencing date, the day that you're going to get sentenced. It has to be delivered to your criminal defense attorney because your criminal defense attorney has the right to go over that with you to see what the recommendations are. And that is where having somebody who is persuasive and can understand somebody's circumstances, understand where they come from, what their background is, as an attorney is so incredibly important because your attorney is going to use that report to develop an argument to minimize the amount of time you have to spend in a cage when you're convicted of a crime. And it's one of the things that is sort of frustrating as I sit in some courts and watch some lawyers operate. Sometimes it seems like not a whole lot goes into the PSI counseling and not a whole lot goes into the arguments at sentencing. And I think that is a real, I think that's a real mistake if your attorney is not really kind of hyper focused on that because there are times, I can't tell you how many times that judges will change their mind. You can tell they're coming in, or they'll even say it on the record. When you appeared here, Mr. Smith, I was fully anticipating doing X, Y, and Z. However, through your counsel, he's shown that I should take I should do a different thing. I should send you to a rehab or something instead of prison. And that's really good. In a worst case scenario, it feels really good as an attorney when we're able to lay out the facts and the determining factors, mitigating factors, if you will, that are reasons why a judge should take our recommendation and not just go off the PSI. There's a couple tools that really good attorneys that we try to do this quite often, especially for certain kinds of cases. We try to file what's called a sentencing memorandum, a sentencing memo. Oftentimes, judges are not allowed to take correspondence from people who are on the supporting side of the defendant. Mom wants to write the judge a letter and say how great Johnny was, so please go easy on him. And the judges don't read that stuff. And some of those communications are actually improper. But there is a proper tool, if you know how to use it, that can help in the situation. You kind of give the judge a sort of a preview, if you will, of your arguments and really get some facts in front of the judge that should be mitigating factors to show why a sentence should go in a particular way. And that's by doing the sentencing memorandum. And it's a document that your lawyer can write, and you go over various factors. Look, this is somebody's background. This is why we think that he needs rehab instead of prison. This is, the support that he has. This is any supporting documentation you'd like to take into account. We'd like you to take into account. And this is filed with the court. It's filed with the prosecutor, and everybody sees it. But good judges, of which I don't know any that would get a sentencing memorandum and not read it, but good judges will read it, and it will be there oftentimes in front of them when they are sentencing. So that's basically the anatomy. That's basically the rundown, the steps, the sequential order of what happens when somebody is charged with a felony all the way through. And hopefully, if you're in this situation or somebody you care about is in this situation, you'll take the time. I know it's a longer video, and I really wanted to give you an experience as if you're coming into my office asking for guidance on how this process works. Hopefully that you'll review the whole video to better understand, because I do think that having this information that I'm sharing with you can alleviate some of the questions and concerns and often misunderstandings of what's happening next in the process. So if you or somebody that you care about is facing a criminal charge, aggressive representation, competent representation is absolutely essential. And that's what we do here at the Stickley Law Firm. We take a lot of pride in the work that we do. We are very client focused. If you're charged with something, we'll bring you in or we'll visit you wherever you're incarcerated, and we'll get down to the heart of what's going on. Our goal is to limit the amount of time our clients have to spend in a cage and get fair and equitable outcomes so that people leave our care in a better position than we found them. So we're here in downtown Hillsdale, Michigan. We traveled around the state. You can find our information on the comments, on the YouTube channel, on our Facebook, on all the social medias. And if you have a problem, if you have a question, don't hesitate to get in touch and stay safe. We'll see you soon.